what this motion is not, is it's not the case. People should not misunderstand that we're arguing the case per se. What this motion is the first hurdle to arguing the case. Every time you sue the government, they bring what's called a motion to strike. No, the government just doesn't like to have these things heard at all. And we've, in the old days, the government wouldn't do this, but in the last 30, 40 years, because of this movement to fascist state that we have, they fight everything, and they fight it on procedural grounds. I remember when I was studying law, a U.S. federal court judge came up to explain to us what had happened to society in terms of how the judicial process has been perverted. And he used the example of the goat and the cabbage. You know, in the old days, your neighbor, if your neighbor's goat ate your cabbage, you yell at your neighbor, you bargain how much the cabbage was worth, and you just pay for it. You deal with it. And he said in today's day and age, it wouldn't happen that way. Your neighbor would sue you, and the statement of defense would read something like this: we're not neighbors. If we are, you're not one of them. If you are one of them, I never met you before. I don't have a goat. If I have a goat, it doesn't eat cabbage. And if it eats cabbage, you don't own any cabbage. You never grew any cabbage. If you did grow cabbage, I never saw that cabbage. And if my goat ate your cabbage, it was insane at the time. It was not reliable. And so this is what the government basically is saying with this case. We can't bring this case because the issues are not justiciable. They're not for the court to decide. And if they are for the court to decide, Mr. Krem, Kummer, and Ann Emmett don't have standing as plaintiffs. If they do have standing as plaintiffs, well, then there's no cause of action. The law doesn't recognize their action. If their action is recognized, well, it's so feeble and weak that it's bound to lose. So why waste your time? And so it's the goat and the cabbage defense. Okay? And so literally, this is what they've said about this case, is that there's no reasonable causes of action. The charter is not engaged. The claim is outside the court's jurisdiction. The plaintiffs lack standing, and the claim is not justiciable. And so we put in, I put in a 26-page legal factum in response, which in a word says you're full of shit. And they are. The government is.
That's a legal term, isn't it?
Yeah. Yes. You know, this is just nonsense. And to understand this, maybe I give you the benefit of my political analysis, because most people think that lawyers, what they do is really cut, dry, boring, and that's true for most things where you're already in an accepted box, where you're litigating within parameters that you accept. But with constitutional law, it's not that way. By the nature of constitutional litigation, you're saying, here's what the government has set up as legislation, and the framework, we say that breaches the Constitution. By definition, constitutional law starts outside the box and tries to recreate the box, if you will. And so in doing that, you have to understand what's going on in terms of the underlying political evolution and analysis. And I'm just gonna digress slightly to give you an example so you understand. In my view, the courts simply are the courts are a product of their society, and any government or empire, let's call it an empire, for lack of a better word, is interested in what it's interested in. So when this society was not interested in globalization, or the notion of globalization was not, or controlling the financial markets was not on the radar, the Supreme Court of Canada heard all sorts of socioeconomic cases in the 30s, the 40s, the 50s, up until the 70s. You remember Trudeau's wage and price control. They asked the court, can the government impose wage and price controls? And the court had no problem saying, we can determine this issue. That's because up until then, this society was not really concerned with those things. It was more concerned about the Puritan, Victorian issues of religion and the church. So if you were gay or lesbian and you were trying to assert rights in those days, good friggin' luck. Now the tables have turned. The society of the empire no longer cares about those moral issues. So that's why you see this constant drumming and reiteration of asserting and granting of, for instance, I'm just using it as an example, gay and lesbian rights, which it should. But that's not because they're willing to do it willingly now. They no longer care about those issues. But if you go to court on an economic issue or a financial issue, which is where the society and the governments and the world order really cares, now you're going to have the same resistance as you would have had 60 years ago saying, we want to marry as a gay couple. I say, what? Okay, and so that's what you have to understand, that these types of cases 50, 60 years ago were heard routinely by the Supreme Court of Canada. But now that this is what the government is protecting on behalf of itself and its allegiances around the world, then the Supreme Court has obviously taken note. They're more resistant. The courts are more resistant to engage in what they traditionally have always engaged in adjudicating in terms of whether the government can do this with the banks, whether the government can do that with the insurance companies, whether the government can regulate in this way. And so, to understand the resistance we may get on this case, you have to understand that basic undercurrent, if you will, of what the empire or the dictator is interested in. And then his or her courts they tend to follow. Not always, but that's what they've got their eye on. So what I want to do is just take a broad stroke and explain what this challenge is really about. And in broad strokes, it's about three basic issues, but that are intertwined. The first issue is that the government is, through the Minister of Finance, is refusing to do with the Bank of Canada what the Bank of Canada was originally set up to do. That is, provide governments, provincial, initially, when it initially was enacted in 1937, the bank could directly provide interest-free loans to the federal government, the provincial government, and directly to the municipalities for infrastructure and human capital expenditure. That was, public works, schools, hospitals, and whatnot. So long as it didn't exceed 1/3 of the annual budget, and so long as it was paid in the next fiscal year, which most governments had no problem doing. But those loans were interest-free. Interest-free. There was no interest attached to them. That practice stopped in 1974 when the Bank of Canada joined the gang of bankers over in Europe. Now, the only difference between our bank and the other banks is our bank is a public bank. It's the only bank that is a public bank in the G8 countries. The other banks are private banks, including the Federal Reserve in the States. Most people don't realize that's a private bank. And so the first issue is the government, through the Minister of Finance, abdicating his constitutional duty to enforce and apply legislation. You can't just let a piece of legislation turn into an appendix that you remove. If Parliament wants to do that, they can do that. But they haven't done that so far. The second issue that's related to the Bank of Canada is the fact that at these meetings with our Bank of Canada governor, the minutes are held secret. Although the Bank of Canada governor reports to the minister, and under the Act, under the Bank of Canada Act, if there's a dispute on fiscal or monetary or interest policy between the governor of the Bank of Canada and the Minister of Finance, with the approval of Cabinet, the Minister of Finance can simply issue a directive to the bank governor and he has to follow it. There's a myth out there that the minister cannot interfere with the governor of the Bank of Canada. That is just a load of metric horse manure. Okay, it's just not so. Under the Act, as long as Cabinet gives the order in council after the minister issues his directive, he has to follow it. It's our bank. It's the government's bank. It's not the bank. It's not the governor's bank. So that's the second related issue. Now, there's a third issue which is just as important because there's a fiscal symmetry between the first two issues and this third issue. And that is with respect to the budgetary process. Every year, you may or not see it. I mean, people aren't interested. There's this whole pageantry, that happens where the sergeant at arms walks with everybody, and some of them are dressed in red Santa Claus suits, and some of them are dressed in, archaic wear, and they knock on the doors of the House of Commons. And that's when the Prime Minister and the Governor General go in to give the speech from the throne to the House of Commons. Now, that exercise is not pageantry. It's a constitutional requirement before Parliament can tax, to give the government, or the Queen, as it were, the money to spend for that fiscal year. Before that money is given over, the Queen, the government, has to explain to the House of Commons, the MPs, what its agenda is for the year and what it intends to spend money on. Otherwise, it doesn't have to approve the budget. And as you know, if they don't approve the budget, that's non-confidence, the government falls. And that comes from the, I'll get to your question in a second, I just want to complete my thought. That is required, the origins of that are in the Magna Carta and the English Bill of Rights of 1689 that continue today under sections 53 and 54 of the Constitution Act 1867. And that is the expression that you do recognize, which is no taxation without representation. So you cannot tax without the MPs imposing the tax. In order for the MPs to impose the tax, they have to know what you're going to spend it on. And that's what you get in the throne speech, the speech from the throne. And so every year passes, and I think most of us, most Canadians, don't understand the constitutional significance of that act. Now, in the throne speech, in the budget, there is one really critical piece of information that the Minister of Finance doesn't give, that the tax lawyers and even some commissions, the Carter Commission, complained about. And that is setting out what the actual revenues are that the country collects before we transfer back money to taxpayers, including single mothers and big corporations, through the tax credit system. So students, you recognize your tax credit, your personal tax credit of $7,000 and change a year. Now, why is that important? It's important because every year you'll say, as an example, the government will say, we have revenues of $200 billion. In order to pursue our agenda in accordance with our speech from the throne and all of that, we need $240 billion. Therefore, we have to run a deficit, $40 billion this year, which would be added to the national debt, which is around, I can't remember now, the 600 billion range, I can't remember, I lost track of it. So, but that's not actually accurate. We collect, for example, maybe $300, $400, or $500 billion a year. We then transfer them back through tax credits to the taxpayers that go from the individual right to the mega corporations, and then we have 200 left. Now, why is that important? Well, if the MPs knew that we had 400 billion, they may decide to shave the tax credits and not run a deficit for that year.
Good point.
Okay? And because they don't have that information, we're getting taxed without our representatives, the MP in the House of Commons. It's a constitutional violation of the right to taxation with representation. That's one of the issues. That's one of the breaches. I won't bore you with the other legal arguments, but essentially that's it. Now, the reason that's important is that since 1974, when the Bank of Canada stopped giving interest-free loans to the governments, there's been an uncanny, almost frightening, and I'm sure people will confuse me, of conspiratorial symmetry between the deficit and the interest payments on the friggin' debt. And what I see where I stand is a country that's the subject of a form of opium war. We're hooked onto interest and debt by force. We become victims of a drug addiction that doesn't need to be there. And so if you look at every budget and every year, not every year, but most years, the deficit turns out into what we pay in interest. So that $40 billion a year, for instance, is our interest payments on the accumulated debt of all the deficits we've had since that time. And so I believe the figure was what, just under $2 trillion in interest have been paid since 1974, which is about 10 years of budget for the country. Was it 1.9?
1.1 trillion.
Oh, I'm sorry.
That we've paid in interest on the federal debt alone.
Right, and so if you figure your average annual budget goes between 240 and 250, that's a lot of money. That's a lot of money in 38 years we've paid on it in interest. What's even more offensive is that commercial banks get their money right now from the Federal Reserve. Right now they're getting at 0% interest, and from the Bank of Canada they get it 1/4%. When they lend it to our government, we pay as taxpayers a much higher interest rate. So it's a fraud that they're imposing on the taxpayer. If the Bank of Canada can give it to the commercial banks at 1/4 of 1%, then they should give it to the government at least at 1/4 of 1% or at 0% as the bank is mandated to do. And when you tie all this in with the fact that these policies really are not even dictated by our bank governor or our government, they're dictated by the bankers over in Zurich, it becomes more offensive because we've relinquished sovereignty under the Constitution to these foreign private banks. And you know, and this is not a conspiratorial analysis. I've pled conspiracy by these people in the statement of claim. You know, when people say that, you know, when people tell me that I have conspiracy theory, that I'm spouting conspiracy, I often tell them that, well, that if I'm a conspiracy theorist, you must be a coincidence theorist. And if you look at any criminal code in Western democracies, coincidences are not against the law. A conspiracy carries a maximum of 14 years in jail. Why? Because conspiracies happen on a regular basis. They're a criminal offense. But you won't see a coincidence as a criminal offense. So these are not coincidences. These are planned, and they're really detrimental to our sovereignty, and they turn the Constitution into a roll of toilet paper, essentially. And so now, you know, I don't know if you've seen the papers in the last couple of weeks. When I was doing, in the late 90s, 99, 2000, I was doing mostly all of the so-called terrorist security certificate cases in the country. And during 2 of those cases, I got up in court and I pounded the desk essentially and said, listen, my phones are being wiretapped. I resent the fact that solicitor-client conversations with my clients are being wiretapped. I know that the CSIS Act allows for it. I just want to confirm because I want to take a constitutional challenge to it. And of course, the government lawyers ridiculed it as conspiracy theory, and you know, this and that, and I was being colorful. And so, and they went up and down it. After Charcouille came down from the Supreme Court of Canada in 2007, where these procedures were declared unconstitutional, the government was required to give more disclosure on these cases. And one of my ex-clients is being represented by my current associate in the office, and sure enough, they disclosed early this year that my phones were wiretapped for 10 years. And so away goes the conspiracy, and maybe it's a coincidence, I don't know, but now they're not talking about it anymore, you know, because now they're not interested, they had to disclose it. And so these things, if you're accused of being crazy and conspiratorial, well, you should take it as a compliment. Because if you're sane in this insane world and in the insanity that our government is buying into, then you've got to question your sanity, you know? And it's just you see it in the papers today. You know, no surprise to anybody. Bill Krem predicted. I hope you're still wrong, Bill, but they're rattling against Iran. This is a prelude to pre-election invasion, I'm sure. We shut down the Iranian embassy, the Canadian embassy. I'm sure Obama's going to use this as an excuse and start bombing before the elections to look tough. I mean, these things are not, you know, if you said this as you did at our first press conference, people would say you're conspiratorial. So don't worry about that. This claim has a lot of basis. It's grounded in law. If we get a dishonest judge, he or she will strike parts or all of it, will appeal it. But there's nothing in this statement of claim that we want the government to fess up that's not grounded in solid legal argument. Okay, and they've simply taken the hillbilly shotgun approach, buckshot approach, hoping that some of the buckshot hits somewhere. And some of their grounds are really even contradictory. If they, they say that the case is not justiciable. Well, if the case is not justiciable, then the other issues don't matter. The court doesn't need to hear whether or not you have standing, whether or not the causes of action are solid in law, whether or not we make the case.